In our last lesson, we talked about Article 26 of the Civil Code. This provision was added by our Code Commission primarily to protect the dignity, personality, privacy, and peace of mind of every person. This protection on privacy extends to a person's name, image, likeness, residence, office, or any other place where the general public is barred and only a limited class of individuals are allowed. We also discussed how the causes of action under Article 26 overlap with the crimes of oral defamation and intriguing against honor under Articles 358 and 364 of the Revised Penal Code. While there is some overlap, Article 26 prescribes a whole new set of reliefs, including an action for damages, injunctions, and other reliefs. Today, we're taking a look at Article 27 of the Civil Code. It is the provision on the chapter on human relations that lays down the cause of action against public officers for their refusal or neglect to perform their duties. According to Justice Paras, this provision was taken from the German Civil Code with the view of eliminating the complex system of bribery inside government offices. Itinuturo rin niya ang mga inaabot sa ilang mga empleyado ng gobyerno gaya ng pampabagsak, pampadulas, at pampasalamat. At the end of this lesson, you should be able to 1. Identify the requisites for the applicability of Article 27 of the Civil Code. 2. Distinguish between misfeasance, malfeasance, and nonfeasance. 3. Identify whether an act or transaction is a purely ministerial or discretionary act on the part of the public officer. All of this and more coming right up. Hi, my name is Lex and welcome to Lex in Motion. In this channel, I'll be helping you build your competence, confidence, and capability in law school. Start today by hitting the subscribe button below. New episodes are posted every Friday. Article 27 of the Civil Code provides that any person suffering material or moral loss because a public servant or employee refuses or neglects without just cause to perform his official duty may file an action for damages and other relief against the latter without prejudice to any disciplinary administrative action that may be taken. Kung ikaw kapatid ay sumusunod sa ating mga lessons dito sa Introduction to Persons by this time, ay wala nang kahirap-hirap sa iyo ang pag-unawa sa provision na ito. Walang mahirap dito kapatid, medyo technical lang sa dulo pero kakayanin naman natin ito. From the first part of the provision, we know that this cause of action is available to any person. At ang ibig sabihin nito kapatid ay pasok ang mga natural persons tulad mo at tulad ko. Pasok din sa any person ay ang mga juridical persons gaya ng corporations, city governments, mga NGO at iba pang mga artificial persons na maaaring maghabla. The chapter on human relations is that part of the Civil Code that defines for us the various reasons or legal basis for us to come to court and ask for a relief. Article 27 is one of these causes of action in it accrues when any person like you and me suffers some material or moral loss because a public servant or employee refuses or neglects without a valid reason to perform his official duty. Ang material loss dito kapatid ay hindi nangangahulugan na nawalan tayo ng materyales gaya ng art paper, Oslo paper o pandikit. Material loss here means any measurable loss that is directly imputable to the refusal or negligence of the public servant. Material loss covers rentals, income, or lost business opportunities that you could have earned had it not been for the refusal or neglect of the public servant. Moral loss naman ang tawag sa damages sa iyong reputation o sa iyong mental health. Kadalasan ang material loss ay may resibo, kaya madaling patunayan. Pag-usapan naman natin ngayon ang refusal or neglect to perform an official duty. Tatlo ang uri ng paglabag sa tungkulin na maaaring gawin ng isang government official or employee. Importante ito kapatid, so I hope you pay attention because these concepts will appear again in your readings for criminal law, constitutional law, administrative law, and once again in remedial law. The three forms of misconduct by public officers are misfeasance, malfeasance, and nonfeasance. Misfeasance refers to the improper performance of some act, which might lawfully be done. Misfeasance requires that a public officer or employee does something but he does it incorrectly or improperly. Sa misfeasance, may ginawa naman ang public employee pero hindi niya ginawa ng maayos ang kanyang trabaho. Generally, ang basis nito ay negligence o incompetence. Malfeasance is the performance of some act which ought not to be done. Malfeasance requires that a public officer or employee does an act that should not have been done in the first place. Generally, malfeasance requires that the act must be willful and intentional. Dapat ito ay sinasadya at hindi lang dahil sa kanyang kapabayaan. Nonfeasance is the omission of some act which ought to be performed. Nonfeasance is the failure or refusal to do an act that is well within the scope of a public officer or employee's duties. Article 27 covers acts of nonfeasance only. Dito, liable ang isang public officer dahil hindi niya ginawa ang kanyang trabaho. The way I remember this, kapatid, and I hope you write this down, is this. Sa ilalim ng misfeasance, nagtrabaho ang employee pero hindi niya ginalingan o wala sa ayos ang kanyang gawa. Sa malfeasance, gumawa ang empleyado ng isang bagay na illegal. Sinadya niya ito at kailangan niya itong panagutan. Sa nonfeasance, hindi nagtrabaho ang public employee. The law imposes a duty upon a public officer and such officer refuses to take action. Nonfeasance may be committed willfully or through negligence. Just as in Article 27, the law lays down refusal or neglect without just cause as the basis of the cause of action. Ang isang government employee na ayaw kumilos ayon kay Justice Paras ay maaaring naghihintay ng pampadulas or a gift to facilitate or expedite the performance of a legal act. Kadalasan itong nakikita sa mga approval ng permits or clearances mula sa gobyerno. Ang pabagsak naman refers to the gift that is given so that the public officer or employee will perform an illegal act. Nakikita ito noong 90s sa mga gustong magpasira o magpabura ng kanilang mga marriage contract sa dating NSO. In both cases, most corrupt officials will be expecting a pampasalamat or the gift given in appreciation of a thing already done. When we talk about the duties of public officers, they generally fall into two categories. These are discretionary and ministerial duties. A purely ministerial act or duty is one which an officer or tribunal performs in a given state of facts in a prescribed manner in obedience to the mandate of a legal authority without regard to or the exercise of his own judgment upon the propriety or impropriety of the act done. Ang pagpaparehistro ng birth certificate ay isang halimbawa ng Ministerial Act. Ang hospital, lying-in clinic o kumadrona ay pupunta sa tanggapan ng civil registrar. Dala-dala ang form na sinulatan ng mga magulang ng bata kasama ang kanyang timbang at araw ng kapanganakan. The office of the civil registrar who finds that all of the requirements are present batay sa kanilang mga checklist, has the ministerial duty to issue the certificate of live birth. Dadalhin ngayon ito sa Philippine Statistics Office for validation who will then issue the appropriate form. Ang pagpaparehistro para bumoto ay isa pang halimbawa ng Ministerial Act. So long as pasok ang isang tao sa edad at siya ay nabibilang sa isang barangay, city or municipality, kompleto ang form at wala namang disqualifications, then the duty to register the person as a voter becomes a ministerial duty. Sa ating halimbawa, mechanical ang trabaho ng mga public officers. Once they find that the form is sufficient, that all of the requirements have been met, then they must perform the act of registration. Walang element of discretion or the authority to decide. The duty is ministerial only when the discharge of the same requires neither the exercise of official discretion or judgment. If the law imposes a duty upon a public officer and gives him the right to decide how or when the duty shall be performed, such duty is discretionary and not ministerial. Discretion refers to a limited authority to decide on something. Discretionary acts include how a judge or tribunal decides a case. Discretionary act din ng Congress kung ano-anong mga batas ang dapat nilang ipasa o i-prioritize. Discretionary act din kung hindi sila magpapasa ng batas at pag-aagawan na lang nila ang upuan sa harap ng malaking watawat ng Pilipinas. Discretionary act din ng isang pangulo ang mag-appoint ng isang cabinet official o panatilihin sa pwesto ang isang doktor na sunod-sunod ang sablay. Pasok din sa discretionary acts ang paggagawad ng isang pardon sa isang convicted felon. One more point bago natin iwan ang ministerial at discretionary acts. The law gives us the remedy of the special civil action for mandamus to compel a public officer or employee to perform a ministerial act. The remedy of mandamus will not apply to a discretionary act. We cannot come to the Supreme Court and ask for an order for Congress to enact the national budget and to be united once again. That is a purely discretionary act and there can be no remedy for that. By way of exception, mandamus will not apply on the discretionary act but to force an official to exercise his or her power of discretion. A writ of mandamus cannot order the city mayor to appoint a particular employee. Kunwari ikaw, kapatid, nang nangangarap maging city legal officer. Hindi uubra ang mandamus dyan. Pwede ang mandamus kung pipilitin natin si mayor na mag-appoint na kasi anong araw na. Kahit sino, basta mag-appoint siya. The Supreme Court has consistently upheld that as a general rule, public officers and employees are not personally liable for acts that are within the scope of their official authority and in line with their official duties. Ang isang judge na nag-issue ng demolition order sa mga squatters ay hindi natin maaaring panagutin para sa mga nasirang bahay at gamit dahil ito ay pasok sa kanyang trabaho. Article 27 then becomes one of the exceptions where personal liability attaches to the public officer or employee, this time on the basis of the refusal or negligence of his or her duty. The last part of Article 27 lays down the reliefs available. The person who suffers material or moral loss can file an action for damages or other reliefs. The other reliefs here include the special civil action for mandamus that I have just discussed. Article 27 also provides that this separate action or actions can be filed on top of the criminal or administrative proceedings against the corrupt public officer. From our discussion, we can now lay down the requisites for the application of Article 27 of the Civil Code. 1. There must be a public officer or employee who has a duty to perform. 2. The public officer or employee refuses to or neglects to perform such duty. 3. The refusal results to material or moral loss to any person. 4. The refusal must be based on malice or inexcusable negligence. The fourth requisite, kapatid, is not found on Article 27 but on jurisprudence. With that being said, let's proceed with the cases. In Ledesma versus Court of Appeals, the family of Violeta Delmo filed an action for damages against Jose Ledesma in his capacity as the president of the West Visayas College on July 30, 1966. In this case, Violeta Delmo was the treasurer for the Student Leadership Club. She used the funds of the club to extend loans for some of the students of the school for humanitarian purposes. Jose Ledesma, then the president of the college, wrote to Violeta that her acts were against the school's rules and regulations. She was also informed that she was being dropped from her membership from the club and that she would not be eligible for any school awards. Si Violeta ay candidate para sa magna cum laude at dahil siguro pinaghirapan niya iyon, nang mahabang panahon siya ay umapila sa Director of the Bureau of Public Schools na functionally ay parang CHED ngayon. The director ruled in favor of Violeta and that she had acted in good faith. The director also ruled that the actions of Violeta were sanctioned by the club's advisor. The director also ruled that Violeta should not be deprived of any awards or honors. Natanggap ngayon ni Jose Ledesma ang desisyon ng direktor. Hindi niya binigyan ng kopya si Violeta Delmo. Gumraduate si Delmo na walang award. Humingi man ng reconsideration si Ledesma ay hindi ito pinagbigyan. Kahit natapos na ang graduation ay nilagyan na lang ng magna cum laude ang transcript ni Violeta. The trial court ruled that Ledesma had the duty to inform Violeta of the decision of the director. He also had the duty to enforce that decision. Specifically, he should not have deprived the student of her Latin honors. He knew of the decision ahead of the graduation but he merely let Violeta graduate as a plain student. Violeta died while the case was pending. For these reasons, the trial court awarded Violeta's parents and estate damages amounting to 47,000 pesos. Kung nakikinig ka sa discussion last week, maalala mo kapatid na ito ay malaking halaga dahil si Arcadio S. Arcadio ay nakabili nga ng bahay at lupa sa halagang, wait for it, 31,000 pesos. On appeal, the Court of Appeals affirmed the ruling of the trial court. The issue in this case is whether or not Ledesma, in his capacity as the president of a state college, is liable under Article 27 of the Civil Code. The Supreme Court, speaking through Justice Fernan, ruled that Ledesma was a public officer being the president of a state college. He had the duty not only to inform Violeta, but also to enforce the decision to confer Latin honors upon her. His refusal to do his duty resulted in the moral suffering of Violeta, which, if I can add kapatid, ay maaaring naging dahilan na rin ng kanyang pagkamatay. In this case, is the enforcement of the decision of the director a ministerial or discretionary act on the part of the college president? In the enforcement of the decision of the director, the president here has no choice. It's a mechanical act and therefore a purely ministerial act. Sa pagtanggi ni Ledesma na ibigay ang Latin honors kay Delmo, ito ba ay misfeasance, malfeasance, or nonfeasance? The answer kapatid is nonfeasance, where there is a duty to perform and the public officer or employee does not perform the duty, then there is nonfeasance. Our next case is a little bit more straightforward and illustrates the other reliefs under Article 27 of the Civil Code. Sometime in 1960, Abelardo Javellana and 5 other municipal councilors of the municipality of Buena Vista in Iloilo filed an action for mandamus against Susano Tayo in his capacity as the mayor. Abelardo Javellana and 5 other councilors held their regular sessions in 1960. As provided by the rules. The mayor, Susano Tayo, refused to attend the sessions because the council was controlled by an opposing political party. Dahil nga ayaw umattend ni mayor ng regular sessions, hindi napipirmahan ang mga payroll ng ating mga konsihal. Hindi na rin naaaksyonan ang mga resolution na kanilang pinapasa. The councilors went to court for the special civil action for mandamus, praying for the court to order the mayor to sign the payrolls and to act on their resolutions. They also presented one of the councilors, Ezequiel Goles, to prove his moral loss as the result of the mayor's refusal to attend. The trial court ruled in favor of the councilors. Sana daw ay naging mabuting halimbawa si mayor ng good governance. Kahit pa ang konseho ay hawak ng kabilang partido. Ang ganda ng sinabi ng trial court dito kapatid, and let me read it for you. Any member of the council should enter the session hall not as a representative of any political party or group, but as a representative of the people of the municipality whose interest and welfare should be safeguarded by the council. In entering this hall, he must lay aside his political affiliation, interest, and consideration because it is the sworn duty of every councilor to perform his duty with justice and impartiality. Not to attend the meeting constitutes an abandonment of the people's welfare. Ang kanilang pagkukulang, looking back kapatid, is their failure to prove the moral loss on the part of the other councilors. They only presented one of their ranks, thus only Ezequiel Goles became entitled to damages under Article 27. The Supreme Court, speaking through Chief Justice Bengzon, ruled that the contention of the mayor that there was no quorum or the minimum required members for the council to legally do business has no basis. 6 out of the 10 councilors were present. Susano Tayo refused to attend the sessions for partisan reasons. He had a duty to be present to act on the resolutions passed by the council and to sign the payroll for those who have attended. For his violation of his duty, he must be liable to Goles, who was able to prove the moral loss. In this case, kapatid, makikita natin ang application ng writ of mandamus. Ang pagpapasahod sa mga nagpunta sa session ay mechanical act yan. Kung pumunta, di pasahurin natin. Walang discretion o decision making na involved. Ang pag-approve o pagde-deny sa isang resolution ay isa namang discretionary act. Nasa kamay na ni Mayor yan kung ano ang desisyon. The mandamus here does not compel the mayor to approve or deny the resolution. What the mandamus does here is to force the mayor to exercise his discretion. The mandamus is there to force the mayor to act, but does not tell the mayor how to act. sa pagtanggi ni Mayor na kumilos o magpasahod ng kanyang mga konsihal. Ito ba ay misfeasance, malfeasance, or nonfeasance? Where there is a refusal to perform a duty, ang sagot dyan, nonfeasance. To summarize tonight's lesson, number 1, Article 27 grants us the cause of action against public officials who refused or neglect to perform their official duties. 2, the reliefs under this provision include damages and the writ of mandamus. 3, mandamus is the proper remedy to compel an official to perform a ministerial act and by way of exception to compel the exercise of discretion. 4, Article 27 does not cover acts of misfeasance or malfeasance but only applies to acts of nonfeasance. Salamat kapatid at inabot mo ang ending ng episode na to. Salamat at sana ay may napulot ka sa ilang minuto nating kwentuhan. There will be a quiz in the description down below for me to know how well you have understood this lesson. Please post your score kahit mababa. If you would like us to continue with the lessons on Intro to Persons, please let me know by typing yes in the description down below. Thank you so much for watching. Like and share this video for good law school karma and I will see you next Friday.